You know, there have been some comments made today, in particular, I think, by the victim, Mr. Wright's family. So let me just kind of express some thoughts that come to mind. There was a lot of mention that Mr. Wakey was out and free was the word used while this case was pending. You know, our system of justice is built on deep concepts of due process and fairness. In fact, it's my job to make sure, when I say my, meaning a job, has the duty to make sure that all of those constitutional rights are protected. For a victim, for a defendant, for the attorneys, for the witnesses, for jurors, for everybody, the public. And that is an initial job of a judge, is to determine the safety of the community if someone gets out or it remains in jail. A judge, not I, but another judge, I believe in this case, made the decision that Mr. Wakey, that it was appropriate for him to remain out on bond, out of custody. That's not something Mr. Wakey did. Keeping someone in jail is not supposed to be a punishment prior to trial. In this country, folks are presumed innocent until proven guilty by evidence to the exclusion of and beyond any reasonable doubt. And so folks oftentimes, many times, are out of custody pending trial. And that's no slight to any victim. It's no slight to a family. It shouldn't be considered that way. The analysis by a judge at that point is safety to the community, and I hope folks understand that. I'll touch on it just a moment. Mr. Wakey mentioned that he was not able to speak. I think the victim's family probably understands. When someone is accused of a crime, they get lawyers. It's not appropriate, frankly, to be talking to the media and the public and making comments while a case is pending. And the obvious reason, folks, is due process. We want a jury to hear the case uninterrupted, uninterfered with, so that a jury makes a decision based on the evidence presented during a trial, and to that alone. And so for those reasons, Mr. Wakey is right. Shouldn't speak to others, shouldn't talk in the media, shouldn't apologize to folks for anything that he feels he may or may not have done. It's how our system operates, and rightly so that we can protect the process of our judicial system. And I hope that's understandable for everyone. Mr. Wakey, I think I switched divisions. I came into this division at some point. This case I know has been going on for a long time. Partly that's to blame perhaps for the rotation of judges, but I do know that this case has taken some time, so I understand when you say you want this to have some closure. For you, and I'm sure for Mr. Wright's family, of course. I came in, I think, to the case when we had a stand your ground hearing. That is a decision the court has to decide whether or not the case should be barred or precluded from bringing forward charges against you based on the concept of self-defense. I found that the state had established and was able to prove your guilt in this case, and that it would be up to a jury to decide if self-defense was valid in this case, and I denied your motion for this case to be dismissed. We eventually got to trial, I think fairly recently. Your case was presented to a jury, and the jury also did not believe in the self-defense. They believed that you did in fact commit an intentional act that resulted in the death of Colton Wright. I am going to, at this time, although the defense has established by competent evidence the reasons for departure, I'm going to find that a departure is not appropriate. I've considered all the evidence. Again, I've sat in hearings and trials. I was here for the jury trial. I presided over the jury trial. I've listened to your family and your friends, your mother who's present on the phone today. I've read the letters that have been presented from your family and friends and from Mr. Wright's family and friends. And I will sentence you as follows, taking everything into consideration. I will adjudicate you guilty of the charge of manslaughter. I will sentence you to 25 years in the Florida State Prison. You shall receive credit for all time served, including today. As to the charge of tampering with the physical evidence, that is your destroying the photographs, deleting them, the evidence in this case, which was able to be retrieved and presented and shown to the jury in these thumbnails, I will adjudicate you guilty and sentence you to 5 years in the Florida State Prison. Both of these counts will run concurrent with each other. He'll receive credit for all time served on each count. I'll order that you have no contact whatsoever with the victim's family in this case. I'll order and reserve on restitution. I'll set as a civil judgment against you the court costs, a $100 fee to the state attorney. The bailiff is going to take your DNA this morning, or rather this afternoon, unless you provided them before, as well as your fingerprints. Mr. Wakey, you have 30 days to appeal the judgment and sentence of this court. If you cannot afford an attorney for that appeal, one will be appointed to represent you. The court will be adjourned.
All rise. Court's in recess.
Right me.
Yeah.
No, okay.
We're gonna have an coming down for two.